Welcome to Chapter 7, Courts and the Quest for Justice. So we were going to be looking over what roles do courts play in society. So on a practical level, a court is a place where arguments are settled. But at best, courts really just provide a process, an environment in which the basis of an argument can be decided through the process of the application of the law. Courts have a lot of power in the criminal justice system. They can bring to bear the authority of the state to seize property or restrict individual liberty. But given that the rights to own property and to enjoy personal freedom are enshrined in the Constitution, a court's legitimacy in taking such measures must really be unquestioned by society. So this legitimacy is based on two factors: impartiality and independence. So let's talk about due process and crime control in the courts. So when we're talking about due process, the due process function, I want to make sure on here. No, okay, I want to make sure the slides didn't go a little bit further through before I started into this. So due process, let's start with that function. This is the primary concern of early American courts, was to protect the rights of individuals against the power of state. And therefore, this due process function of the courts is to protect individuals from the unfair advantages that the government, with all its resources that a lot of individuals don't have, automatically enjoy. So, and if we see it in this slide, constitutional guarantees such as the right to counsel, the right to jury trial, protection from self-incrimination are all equalizers in the contest, if you will, if that's the right term, contest between state and the individual. So the crime control function of the courts, emphasizes punishment, right, and retribution. Criminals need to suffer from the harm that they've done to society, and it is the court's responsibility to see that they do so. So rather than using due process rules as equalizers, then the courts should use them as a protection against blatantly unconstitutional acts. Now, the rehabilitation factor, it can be a third view of the court's responsibility. It's based on the medical model of the criminal justice system. And in this model, criminals are like patients, and the courts perform the role of physicians who dispense a type of treatment. So the criminal is seen as sick, not necessarily evil, and therefore treatment is morally justified. And then, of course, the bureaucratic function. So in general, a court may have the goal of protecting society or protecting the rights of the individual. But on a day-to-day basis, that the court has the more pressing task of dealing with the cases that are brought before it. So like any government bureaucracy, a court is concerned with speed and efficiency, and loftier concepts such as justice can be secondary to the judge's need to wrap up a particular case before 6 o'clock so the deadlines can be met. So how do courts operate? This is the concept that's really important for you guys to understand. The United States does not have a single judicial system, but 52 different systems, one for each state, the District of Columbia, and the federal government. So for jurisdiction, we define that as the authority of a court to hear and decide cases within an area of law or geographic territory. Before any court can hear a case, it must have jurisdiction over the person's involvement in the case or its subject matter. The jurisdiction of every court, even the United States Supreme Court, is limited in some way. So generally, a court can exercise its authority over the residents of a certain area. And the U.S. Congress or state legislature can determine what acts are illegal within that geographic boundary if it controls it. So this gives federal or state courts jurisdiction over those crimes. So most criminal laws are state laws. So the majority of all criminal trials are heard in state courts. Many acts that are illegal under the state law are also illegal under federal law. So, as a general rule, when Congress criminalizes behavior that's already prohibited under state criminal code, the federal and state courts both have jurisdiction over that crime, unless Congress indicates otherwise in the initial legislation. Thus, there's this concept of concurrent jurisdiction, and this occurs when two different court systems have simultaneous jurisdiction over the same case. And this is quite common. Bank robbery is one that can go federal or stay local. A lot of child pornography laws can go federal or stay local. So those are just some examples of cases that the feds may pick up. Okay, so multiple states can also claim jurisdiction over the same defendant or criminal act, depending on state legislation and the circumstances of the crime. The concept of jurisdiction encourages states to cooperate with each other. So this process of extradition, I'm sure you guys have heard that term, is a formal process by which one legal authority, such as one state or nation, transfers the fugitive or suspect to another legal authority that has a claim on that person. Excuse me. So what about international jurisdiction? So under international law, each country has the right to create and enact criminal law for its territory. And therefore, the notion that a nation has jurisdiction over any crimes committed within its border is well established. The situation becomes more delicate when one nation feels the need to go outside its own territory to enforce its criminal law. International precedent does, however, provide several bases for expanding jurisdiction across international borders. We also know about subject matter jurisdiction. This is jurisdiction over subject matter that also acts as a limitation on the types of cases a court can hear. State court systems, including the courts of general unlimited jurisdiction and courts of limited jurisdiction. Now, courts of general jurisdiction have no restrictions on the subject matter they may address. Courts of limited jurisdiction, also known as the lower courts, handle your misdemeanors, your civil matters under a certain amount, usually $1,000. But many states have created special subject matter courts that only dispose of cases involving a specific crime. So traffic courts, drug courts, mental health courts might be examples. So let's talk about the difference between trial and appellate courts. So another distinction is between courts of original jurisdiction and courts of appellate or review jurisdiction. Courts having original jurisdiction are the courts of the first instance, the trial courts. And trial courts are defined as courts in which most cases begin in which questions of fact are examined. They are designed to determine exactly what events occurred that are relevant to the question of this defendant's guilt or innocence. Courts have appellate jurisdiction or act as reviewing courts, appellate courts. And they're defined as courts that review decisions made by lower courts, such as trial courts. They are also known as the Court of Appeals. But in general, cases that can be brought before appellate courts only on appeal by one of the parties in the trial court. So an appellate court, let's go back here, does not use juries or witnesses to reach its decision. Instead, judges make the decision. And they're looking at whether the lower court's ruling should be affirmed or reversed. And if the ruling's reversed, it may also be remanded, which basically means it's just sent back to the original court for a new trial. So appellate judges present written explanations for their decisions, and those opinions of the court are the basis for a great deal of precedence in the criminal justice system. We've talked about some Supreme Court cases already in class that guide the criminal justice system. So the dual court system refers to the separate but interested court system of the United States. It's made up of the courts on the national level and the courts on the state level. This is a great graphic to help you guys understand this. Federal and state courts both have limited jurisdiction. Generally, federal courts preside over cases involving violations of federal law, and state courts preside over cases involving violations of state law. So when concurrent jurisdiction exists, both sides can try the defendant under their own laws, or one side can step aside and let the other decide the fate of the defendant. But because the federal court system has greater resources than most state court systems, federal criminal charges often take precedence over state criminal charges, mostly for practical purposes. So how do states organize their courts? So typically a state court system includes several levels or tiers of courts. State courts can include things such as lower courts, limited jurisdiction, trial courts of general jurisdiction, appellate court, and then of course the state's highest courts. So let's talk about courts of limited jurisdiction. So most states have local trial courts, and they're limited to trying cases involving minor criminal matters, such as traffic violations, prostitution, drug and disorderly conduct. And these are really minor courts or minor, let me see where we are here. These are really minor courts, and there can often be no written record of the trial proceedings that are decided by a judge rather than a jury. Defendants have the same rights as in other courts, though. That needs to be remembered. Even though it's a lower court, they have the same rights. Most minor criminal cases are decided in those lower courts. And courts of limited jurisdiction can also be responsible for the preliminary stages of felony cases. Arraignments, bail hearings, prelim hearings, those often will take place in the lower courts. So magistrates, or in some states, municipal court judges, preside over courts whose jurisdiction is limited to disputes between private individuals and to crimes punishable by small fines or short jail terms. But in most jurisdictions, magistrates are responsible for providing law enforcement agents with search and seizure warrants. So there are specialty courts that exist as well. I mentioned that a little bit earlier. These are more problem-solving courts. So here's just a few examples. These cases or these courts, they not only remove cases from the rest of the court system, but they allow court personnel to become experts in a particular subject. So some of these courts might be drug courts, which are going to, of course, deal only with illegal substance crimes, veterans courts, which will handle factors that are linked to criminal behavior by those who have served in the U.S. military, like PTSD, substance abuse issues. Juvenile courts, of course, specialize in crimes committed by minors. We might have domestic violence courts, which are going to deal with child and spousal abuse, and mental health courts, which focus primarily on the treatment and rehabilitation of offenders with mental health concerns and disorders. We are going to pause here and we will be back.